All right. Sorry for that. I had to get everything signed up. We've got or signed in a plea and arraignment calendar this morning with a bunch of folks who've already waived and won't be here. And then maybe a hearing on a constitutional speedy. Let me make that echo go away. Okay. Let's start with plea and arraignment. Position one is Rontez Way. You, Mr. Way? Good morning. Is Ms. Rockwell your lawyer? Any
Good morning,
idea where
Judge.
she's online? Great. Let's get her on the screen. There she is. Good morning. So plea and arraignment. Mr. Way has had some issues with his ankle monitor. So we should talk about arraignment and then we should talk about ankle monitor and how long he's had his ankle monitor on. Let's start, Ms. Rockwell. Mr. Way, why don't you come on up to the podium so you can see your lawyer and she can see you. We'll get the podium right there. Excellent. All right. Ms. Rockwell, is Mr. Way waiving arraignment or does he want to be formally arraigned this morning?
We will waive arraignment, Judge, formal arraignment.
Okay, and you will get one of those nice forms to Ms. Nelson sometime soon?
I will, Judge, but we probably are because he's a transfer from non-complex.
Oh, well, let me look. I'm pulling his case up now. Sometimes that's clear in the docket that there was, there was, okay, in January, so we don't need to waive arraignment again. It looks like, there it is. Ms. Rockwell waived arraignment. Fantastic. So we're good there. We need to get a scheduling order in place, and we'll do that. So let's talk about the ankle monitor. How long have you had an ankle monitor?
Since about 22, the end of 22, you know.
Okay, that's a long time. Has the county been paying for it or have you?
So it was a condition of my bond.
Right, but are you paying $100 a month for the ankle monitor or you just got this thing on your ankle and that looks like county's paying for it? So Judge Manning gave you this bond in March of 2023. You've been in jail for a long time without indictment. So she set a bond and you've been wearing the ankle monitor since then?
Yes, sir.
Okay. Got it. Do you know if it is with A&A like Talatrix or did they swap it out?
It was with A&A and my ankle monitor went dead. The charger broke, well, the actual ankle monitor broke.
Yeah.
And I tried to get it repaired, so I never reached anyone from A&A. Then I connected with Ms. Rockwell and understood that they had went out of business. So I had to go to Second Chance, I think.
Second Chance. It's more like they went out of contract. A&A may be out there, but the county now does business with Second Chance.
Okay.
So you swapped it out and you've got a Second Chance one now?
Yes, sir.
Okay, got it. All right. Ms. Davis, this will be your case? I didn't mean to catch you mid-sip there.
Yes, Judge, this will be my case.
Okay. Mr. Way has had his ankle monitor on now for a couple years and he's charged with theft by receiving. I'm wondering if maybe what's the state's view on modifying the bond to remove the ankle monitor requirement?
There is some history here.
Okay.
So, at this time, I wouldn't feel comfortable consenting to the ankle monitor being removed.
Okay.
I will defer to the court.
When you say there's some history, tell me what you mean. There's some criminal history because this case got transferred here.
Yes.
So if I look at that, it looks like from long ago in the early 2000s, there were a series of Fulton County convictions, and then there's something from Cobb from 2016. But they're there. Is at least six convictions.
Yes.
But they do seem to be when Mr. Way was younger, maybe thinking about life in a different way.
Correct. The last charge in Cobb is the same offense as count 3.
Yeah.
And so, of course, we have concerns with that.
Yep.
Because this is the second instance.
Right.
being with a firearm,
Yep.
knowing that you're prohibited from doing so.
Can't say goodbye to the guns. Okay. Ms. Simpson, good morning.
Good morning, Judge.
Is Mr. Way on active probation?
No, Judge.
Okay. Are you able to tell from looking in your system if when he was on probation that went smoothly or didn't go smoothly?
If you allow, give me just a few minutes and I can verify that for you.
That'd be great.
Let's see. He had 2 first offender cases with us that he completed. And it appears he has not had a revocation for his time that he was on probation. So he's good.
Got it. Okay. Thank you so much.
No problem.
Mr. Way, I've got an address for you on Detroit Avenue. Is that still where you stay?
No, it's 2125 Joseph E. Bone Boulevard.
Okay. I'm gonna have you, before you go, fill out an address change form. You can get that to Deputy Gordon, so we've got a good address. So we can update the system. Are you working these days?
Yes,
What do you do?
I work for the City of Atlanta Equipment Operator 3.
Okay. What is that? That sounds very technical. Does that mean you like run a backhoe or a helicopter?
Backhoe, excavator, late truck, low boy,
How long have you worked for the city of Atlanta?
since the March 21st, 2019.
Okay. And is that a full-time, like Monday through Friday or whatever the hours are?
Yes,
Okay.
no, when the weather shifts and it gets cold, I'm the one that keep the roads going.
Okay. All right. Ms. Rockwell, anything else on behalf of Mr. Way?
Can I say?
As long as you don't want to, don't talk about your case.
No, I just wanted to add to let you know that I do have my daughter. I have full custody of my daughter.
Okay.
I had her since last year.
How old is she?
She's 11.
Okay. So something changed in your life and you saw her some, but about a year ago, you now have full custody?
Yes, I guess it's joint full custody, but I'm primary.
Okay.
So she is staying with me. My 21-year-old son stay with me. My daughter is a big part of my life.
Okay.
I don't want to leave her.
Okay. Well, right now, we're not talking about anything like that. I just
Okay.
working through the bond situation, and trying to see how stable things are, so I can decide if it makes sense to take the ankle monitor off. It's been on for a long time. Generally, that should be a 6-7 month thing, and if everyone's doing well, we take the ankle monitor off. But people lost track of your case. It didn't get indicted right away, and then you bounce from one court to another. So I very much want you to be there for your daughter. And today, all we're doing is figuring out the best way to move the case forward.
Okay.
Okay? So if you'll fill out that form. Ms. Rockwell, anything else on behalf of Mr. Way?
Just that I did, in keeping with your honor's kind of trend, I did file a motion to remove the ankle monitor. I don't like to come into court and ask for anything. A dog that comes with a bone leaves with a bone. I understand now that they might have said he's in violation of his ankle monitor, but I can tell you this, what I know about him is home, work, and church for him. His record is bad, but it's old. He is a coveted employee of the city of Atlanta. When everybody was out, when everybody was at home, staying inside during COVID, he was out keeping the road safe. They adore him at the city of Atlanta. And he is a supervisor, he's very lucky, because sometimes you can't keep a job when you've got, or can't even get a job when you have somebody must have given him a chance. So I'm gonna ask the court, if the court, I don't know why he why the ankle monitor makes the state feel any better or safer. There's not really a victim in the case. So I would ask the court to consider removing the ankle monitor. All other conditions remain the same. No drugs without a prescription, no gun, no further violations. I would ask that a 24-hour curfew be lifted. He's got 3 children, 2 that he's taking care of. I know when you have a 21-year-old, sometimes they never get off the payroll. So I know about that, Judge. I don't know if you do, but he's got an 11-year-old and he's got a great job, and we're gonna have to move through this case. So I'd ask the court to take him off the monitor, please.
Okay. So that everyone knows, the reason why I brought up the monitor, well, 2 reasons. One, it's been on longer than we usually see, and this is not a case where we've got a victim. I mean, there is, I guess it's the person. This gun apparently was a stolen gun. I don't want to get into the facts of the case. And so you were supposed to stay away from someone named Randy Keenebrew. But it's not the type of case where it's aggravated stalking or something like that. But according to Second Chance, you were away from your address, and they have your current address. Our system doesn't, but Second Chance has the Joseph E. Boone, so that's good. And their system showed that you were not at your address at some point when you were not working or at the doctor or in court. So I don't have more specifics than that. I just know that put it on my radar so that when I was meeting you today for the first time, we were going to talk about what was going on with the ankle monitor. I didn't realize at that point that you had had the ankle monitor for over 2 years. And it sounds like for the most part, there had not been issues there. I've heard from probation. Ms. Davis, anything else from the state on Mr. Way's case?
No, Your Honor.
Okay. Discovery may have, well, let me ask Ms. Rockwell, did you already get discovery, Ms. Rockwell, from the non-complex attorney, or should Ms. Davis get you another set?
I'm sure that let me just
She
say
may
this.
know, actually. Did you do this case before?
I did not. However, discovery was sent to Ms. Rockwell on May the 1st.
Excellent.
Just a little bit, about 30 days ago.
Okay.
Oh, okay, wonderful. So I'm on leave right now, but I'm sure that it's all there. And I would just ask that, does the court do the scheduling order? Is that something I have to fill out?
No, we'll do that. So the result of this morning will be, 1, a scheduling order will go out that will give the state a deadline to provide discovery. You've already done that. And then you'll have a deadline, Ms. Rockwell, to file motions. You know what these orders look like, but Ms. Nelson will get that out, and that'll ensure that the case moves along. Mr. Way, you will be back in court either because Ms. Rockwell has filed some kind of motion, like say a motion to suppress. I don't know the facts of your case, but maybe you were driving and Ms. Rockwell looks at it and thinks it was a bad stop, that they pulled you over not because it says here you didn't yield, but maybe she's going to say it's just because you look suspicious, and the police don't get to pull someone over just because they look suspicious. So we'd have a hearing about that. But she may look at it and say, nah, it was a good stop. We need to figure out how to work this out. And she'll work with Ms. Davis, the prosecutor. And that would be the other time I'd see you, is because you all have resolved the case. If not, we'll get you in court for a trial. Any questions about any of that?
No, Your Honor.
Did you fill out that address change form?
Yes, sir.
Okay, we've got that. I am going to modify your bond and remove the ankle monitor requirement. The county has been spending hundreds and hundreds of dollars over the last couple of years. It sounds like for the most part, you've stayed out of the way of things you're supposed to stay out of the way of. Keep doing that, because the quickest way to lose your bond is to get picked up again for something. So it sounds like you're not interested in doing that, and that's good. There was Mr. Way of the early 2000s picking up all those convictions, and now there's Dad Way taking care of his daughter. So keep doing that, and we'll see you for either that motions hearing or because your case is being resolved. Any questions?
Are they gonna remove it here?
Are they going to remove it here?
Yes.
No, what'll happen is I'm going to enter an order. Ms. Rockwell will get that to you, and you'll need to bring that order with you to Second Chance. You go to them.
Okay.
You know where they are because you swapped out the monitor, but they're not hard to find. You show up there and they will, with a copy of that order, remove it. I'll actually be sending them a copy of the order so they know it's out there.
Will I get a, excuse me, I apologize for cutting you off. Will I get a physical copy before I leave here?
No,
Okay.
because I haven't done it yet. But I'll do it. Ms. Rockwell will get it and she can email it to you or however she's going to do it. She's on leave, so she can work hard on your behalf, but she may not be able to hand it to you, but she could always email it to you. Okay?
All right.
All right.
Thank you. I appreciate you.
Okay. Ms. Davis, anything else from the state?
No, Your Honor.
All right. Thank you. Mr. Way, you are free to go.
Thank you. But it will be today. It will be today, right?
What?
With them taking it off.
No,
It won't, okay.
it will not be today. It'll be soon. You've had it for 2 years. Deep breath. But it will be this week. I will do that order.
Okay.
It'll get to Ms. Rockwell and she'll get it to you.
All right. Thank
Okay.
you. I appreciate you, Judge.
All right.
Judge, that does conclude my business. I don't want to pass up my opportunity. The other day I was in front of Your Honor, just waiting for my case to be called. And while you were dealing with that individual judge, you were able to look in the calendar or on your docket and you noticed that someone was going to have a meeting with Judge Manning for ankle monitor compliance. I do want, I've notified the superiors in the DA's office. I do want the court to know that I've got several instances where those meetings are had and the client and the defendant rather, and the lawyers are not getting, the defense attorneys are not getting notified of that.
Okay. Well, we need to look into
Trying to
that.
fix it.
One, those calendars are gradually fading away. They were designed to reduce the number of ankle monitors that have been on for 2 years or 18 months. And so those will eventually go extinct, those calendars. Two, probably one of these issues is it is targeting monitors that are so old and have been on for so long, and in a lot of cases are unindicted, that notice is going to a person who is not the lawyer of record anymore, but is still in the system. But if you learn about that, let me know and I'll work with Judge Manning. And the goal isn't so much to play gotcha as it is to figure out, do we really need that ankle monitor on that person for month 25, 26, 27, et cetera.
Thank you so much, Judge. And I will include you in the loop. Also, Judge Manning, also one of the deputy DAs, Miss McGillicuddy, said she was going to bring it up and address it.
Okay, well, little preview, we will be rolling out probably in the next month a new standard bond order that has a default of 6 months and the monitor automatically comes off. And a judge has to proactively say, no, I mean for this to be more than 6 months. So that's another reason why I think these Judge Manning calendars are soon going to go the way of the fax machine.
All right. Thank
Okay.
you. May I
All
be
right.
excused, Judge? And I think I'm going to see you on July the 1st.
I hope, I don't know what that is, but I hope so, whatever it
Mr.
is.
Hayes.
Okay.
David John Hayes. Thank you, Judge.
All right,
I'll be
bye-bye.
excused.
Position 2, where there's a waiver of arraignment and he was excused. Let's make sure he's not here. Juan Pantaleon? Nope, okay. My staff excused that. So Ms. Davis, when lawyers file a waiver of arraignment and ask, and it's not a particularly scary charge, we excuse their appearance at plea and arraignment. So we'll get the scheduling order out and then you'll get discovery to this, in this case, it's Mr. Sperling. But they do have to get the green light in advance. Otherwise, if the defendant's not here, then I ask you if you want a bench warrant. But this is one where Mr. Sperling did the waiver. So we'll do the scheduling order. Position 3, Kayla Brown. Mr. Wooten, same situation. I believe Mr. Barber did a waiver. This is a reindictment. Mr. Barber is familiar with the case. But let me see what Ms. Hansberry's email said. He filed a waiver on the 4th and called, and so Ms. Brown was excused from being here today. You'll need to work with Mr. Barber. It sounds like there's more discovery, and in your cases, that's not just like a little red well, but it's like a satellite full of information.
Several gigabytes.
Yeah, that lawyers love that. So I know one of the defendants is supposed to be here, so we can talk about what's happening next, but I think we just have to kind of reset the clock. There'll be a new scheduling order because the next defendant's lawyer needs a chance to really starting from scratch. So let's see what's going on there. Trakella Jones. Hi there. Did I pronounce your first name kind of okay? All right, Ms. Jones. I'm Judge McBurney. It's nice to meet you. Welcome to this case. It's a big sprawling case. Do you have a lawyer? Okay. Are you planning on hiring a lawyer? Okay. When you say not sure, are you wavering between I want to represent myself or hire a lawyer, or wavering between I don't have many nickels in my pocket and so I could not hire a lawyer? Okay. When you say you're not sure, is there a big payment coming in soon, or your finances are your finances and you're in a tricky situation? Okay. I'm going to ask Ms. Wood, who is one of the public defenders in this courtroom, to speak with you when we're done calling this calendar. She's going to ask you some basic financial questions, and it may be real clear that even though you don't feel like Bill Gates, you've got a whole lot more money than what qualifies for appointed representation, but it also may be you're right in that heartland of qualifying, in which case I am going to ask the public defender's office to represent you. That doesn't have to be a forever assignment. It's a good assignment for you because you'll get a great lawyer. But if circumstances change for you and you are able to hire a lawyer, you can always pivot and bring someone on board. That doesn't slow things down. That lawyer is going to need to jump in wherever we were in the process. But what I don't want to do is have you say, well, you know, I think if I save for 6 months, I could probably get a lawyer. We don't have 6 months to wait for that to happen. So I'm going to have you and Ms. Wood talk, and then we'll talk again about what she's not going to give me the confidentials that you shared with her. She'll just say, hey, Ms. Jones qualifies or Ms. Jones doesn't qualify, and we'll go from there. Okay. All right. Mr. Wooten, anything you want to add on that? No, you're good. Okay. The fact that Ms. Jones may qualify for appointed representation based on your investigation, does that surprise you, or it's consistent with what you understand? That would be consistent. Okay. Good. I just want to make sure we weren't running into an area where the state would be saying, now we need to do remember what those hearings are called, where we've got to make sure there isn't, everything's on the up and up. Okay. All right, Ms. Jones, so you can take a seat. Ms. Wood will talk to you when we get through this. Okay. Thank you. We have a Darren Jones. He should be here. He didn't.
Judge, I think he actually did file a waiver. I think it was a little bit late.
Oh, so it just didn't hit Ms. Hansberry's radar. Let's look.
Filed like Friday, so I'm not going to ask for a bench warrant.
Okay. My recollection is that Ms. Mormon in particular has been pretty dialed in. I don't remember if Mr. Jones was here before or if she had always managed to get him excused. So let's see. Yep. It was filed on Friday. Will you no pros the old indictment, or can we, or you don't want to, or what's the plan?
That's a good question, Judge. Before we do anything on that, can I just submit an order to you that adopts the record from the old indictment into the new one, and then I'll figure out what to do.
Sure. No, that's fine. Yes. I would want everything from the 365 indictment to move over here. I don't think we did a ton of litigation, but the record is the record and they ought to be linked. And I guess because you added a defendant, this one isn't 365-01, which is what we tend to see when there's a superseding indictment now. So we're going forward with the 906 number, but sooner rather than later, 365 ought to be closed out.
Yes.
So you consult with your team and then let's just figure out what to do so that can close out. Okay.
Thanks.
All right. So we'll hear back from Ms. Wood and Ms. Jones and then figure out scheduling order, all that kind of stuff. Waive and schedule. And you'll get the additional discovery to Barber and Mormon, and I guess it would be everything to whomever it is that gets Ms. Jones's case.
Yeah, I'm just waiting on a hard drive from.
Okay. And I think you mentioned before, is there a familial relationship between the Joneses?
Yes, I believe that they're siblings, and then Miss Jones is Caleb Brown's mother.
Oh, so they're familial relations all over. Got it. Okay, thank you. Let's move away from that case. Glenn Daniels.
Good morning, Judge.
Hi, Ms. Wood.
How are you?
How was your week last week?
It was very peaceful. Thank you for
Peaceful.
asking.
Was peaceful? Now it's just peaceful in a different way.
Judge, Mr. Daniels is mine, and I apologize. I should have let the court know. He's in custody right now on a misdemeanor. However, I filed a waiver.
Okay, locally in custody?
Yes, at
Okay.
Price Street.
All right. This seems like a resolvable case, but I guess we need Mr. Daniels.
Yes.
Okay. All right. So you're not surprised. I'm gonna look at his bond and figure out, well, wait, if he was out on bond and now he's in jail, then maybe we need to work through the bond. Ms. Davis, much to Ms. Wood and Ms. Rios' chagrin, of late, I began to realize, well, wait a minute, this guy's on bond on a case we've got, and then they report, actually, now he's in jail somewhere. And so I will sometimes sua sponte say, we're having a bond hearing because that seems inconsistent with being out on bond. So just don't be surprised if we have things like that. Your role in those is, as always, to represent the state, but I will be pushing more on the defense to say, look, he's out on bond and he got arrested again. Seems like we need to keep him or her where that person is and just resolve everything. So I'll take a look at that. But in the meantime, you can get this defense discovery and we'll move it along. That's Mr. Daniels. And then Carter Jackson, Mr. Griggs filed a waiver. Oh, are you Carter Jackson? Good morning. Your lawyer, Mr. Griggs, filed a waiver of arraignment and actually asked that you could be excused. And I, through my staff, told Mr. Griggs that you were excused. Word didn't get to you. It's nice to meet you. Your lawyer needs to opt into discovery, and that's something that I'll be reaching out to him. But the prosecutor on this case, who is elsewhere right now, has the discovery, but he needs to hear something from your lawyer before he hands that over. But your lawyer waived arraignment for you, which just means he entered a plea of not guilty on your behalf. And we don't have to read the charges out loud. You know what you're charged with. They're pretty serious. You've got a good lawyer to help you navigate that. I want to make sure we've got good contact information for you. So I have an address on Walden Lake Drive in Decatur. Still a good address? Excellent. Okay. So you'll get notice in the mail when you need to be back in court. More likely you'll hear first from Mr. Griggs because he'll know what's coming up. We would see you next in court because Mr. Griggs files some kind of motion after he gets discovery if he thinks something should be suppressed. I don't know that this kind of case would have a motion like that, but Mr. Griggs will talk to you about that. And then the step after that would be what we call final plea, which would be the last day to resolve your case by way of a plea, where you'd have the opportunity to withdraw that plea if the sentence that I imposed was more severe than what your lawyer asked for. Then obviously at the end of the road is a trial. If Mr. Griggs and you aren't able to reach some negotiated resolution or any kind of resolution with the state, then we bring in 12 jurors, they hear the evidence, and they decide whether the state has met its burden of proving your guilt beyond a reasonable doubt. That's a little ways down the road. There'll be several steps before then when you and Mr. Griggs are talking about the case and figuring out what to do. Okay? Any questions about any of that? Let me take a look at your bond. So how did you get here today?
Family friends.
Good. The main condition on your bond is you're not supposed to drive. That's a fairly onerous condition, but given the charges, I understand why Judge Wolf imposed that condition. You and Mr. Griggs should talk about that, but that continues to be an active binding condition on your bond, so no driving. MARTA, friends and family, all that kind of stuff. Any questions about that? Okay, well, we've got a good address for you. I don't know if anyone from this is Mr. Abadi's case, but, okay. I just noticed in the docket, and it was before the case was indicted, almost a year before the case was indicted, Mr. Griggs did, it looks like he opted in, but I'll reach out to Mr. Abate. I think Mr. Griggs has done what he needs to do to unleash the discovery, but we'll see. Is the trial starting today?
I'm not sure. I just know that
That's where he is. Okay. I don't think Judge Whitaker is getting jurors today, so I don't think they may be talking about it, but I don't think she's getting jurors today. Do you know Eppinger?
he's dressed up, but
She wasn't on the list for jurors, so maybe they're
working it out. That's a good sign, right?
Yeah, would be good. Okay. Mr. Jackson, any questions about anything?
Okay, with regard to the trial that would be starting today, would that be?
No, sir. No. Your trial is if there's a trial in your case, that's literally months away. The next big step is the prosecution has to get to your lawyer all the evidence that the state has. So Mr. Griggs can sit down with you and say, this is a terrible case for the state. You weren't even in the car. Look, here's the dash cam video. It was someone else in the car. He may say, hey, we've got a good fight. He may look at this and say, my friend, we need to figure out how to work this out. Someone died and you were at fault, and I'm not picking any of those options. I don't know anything about the evidence, but that's the next step, is that Mr. Griggs gets that evidence and sits down with you and maybe family to discuss his professional assessment of the strengths and weaknesses of the case. And then, as I mentioned, he may choose to file some motions. He may look at what the police did in this case and think that maybe they did something not consistent with your constitutional rights. And if that's what he concludes, then we'll have a hearing on that motion. If not, then really the next time you'd come to court would be that final plea date that I mentioned. That would probably be towards the end of the summer, because that gives everyone enough time to go through the evidence and negotiate. So ultimately, if this case is not resolved through those negotiations, you will have a trial. It will be in this courtroom, but that will be late summer, early fall at the earliest.
Would you be the judge presiding on my case? Be another
I am the judge for your case, whether it's a plea, a dismissal, a trial. It'll be here with me. You and Mr. Griggs will be sitting there. Mr. Abate and probably a trial partner will be sitting there. So we'll all be here in 8D. Okay? Anything else?
I believe that, so.
Okay. If you have others, reach out to Mr. Griggs and he will do his best to get you answers. All right? I appreciate you being here. I'm sorry for the mix up in the communication.
No worries at all.
All right, sounds good. Thank you, Mr. Carter. Or Mr. Jackson. All right, that's it for the plea and arraignment calendar. We do have Mr. Chasner's motion. Was there anyone here for any other case? Nope. Ms. Wood, if you would speak, please, with Ms. Jones, and we'll pause what we're doing in Mr. Chasner's case once you and Ms. Jones have a chance to connect.
Thank you, Judge.
All right. So, Mr. Furlong, you and Mr. Chasner should come on up to council table unless you've got a different announcement.
Yeah, I'd like to have a pre-trial. I've submitted numerous documentations. I got last psychiatrist report late last week. I submitted to Ms. Milligard. She advised that she's moving and was gonna review it this weekend, so I'd like to have a chance for a pre-trial and see the result.
Okay, well, Ms. Davis is the new sheriff in town, so you guys should feel free to speak for a little while. And we'll figure out what we're going to do today. And it may be that based on what you shared, Ms. Davis says that the state needs to digest it and ask for a little time. No one's leaving today until we sort out the constitutional speedy. And you may choose to withdraw it, you may whatever, but that's what's on the calendar. I'm happy to let you all speak for a little bit, but if it sounds promising, but it's not going to resolve today, we either need to have that hearing or you need to withdraw the motion. Okay? All right, I'll be right here. Thanks.
Judge, I received an email from Chief Carlton on Friday clarifying what we discussed in our meeting.
Yes, I spoke with, well, first Judge Krause and I spoke, and then I reached out to Chief Lane and said, we'll do it however you guys want. I was under one impression, it sounds like it's a different way, and he confirmed that it is sufficient for DCS that the information gathered at the time of the plea is enough to basically create the file, but there's no requirement for the probationer to report. So I'll stop doing that and you can stop doing that. I won't say you got 48 hours to report. I'll say you're gonna go to Hopal and we'll take it from there.
Yes, I'm assuming if we had a revocation into drug court, it would go the same way?
Yes, we talked about that as well. So they wouldn't be re-reporting to probation if they are revoked into drug court or one of the accountability courts, then their case shifts to admin status and they don't need to reconnect with DCS. It would just be when they're being terminated or if they graduate. I don't know how that's going to play out. Often people graduate with a couple years left on probation. I know they want it to be suspended or go away, but that's a different process and a different group of decision makers. And so we'll just need to make sure they know to report upon graduation.
Got it.
Cool. Oh, you looked it up?
No, he just told me, but I'm about to confirm.
Oh, okay. I'm glad we're doing those. We have an ag stalking case that was a direct indictment and there's no grand jury warrant. There's a guy walking around with no bond. It is. I flagged it with Ms. Peterson. Does Ms. Wood know this yet? Okay. All right. So you're going to confirm it. You told her, okay.
She seen me right out.
Okay, why don't you confirm it? And let me look that up. Yep, it's in Odyssey. So if it's in Odyssey, it's got to be in their system. Huh. Okay. I guess we could talk about bond today. She still needs to be processed.
Sure.
But I know that was a topic for which the victims wanted to be heard. I don't know if they're plugged in or how you want to work that.
I believe there is one victim on, who may want to be heard.
They all can be heard. I just want to make sure you had given them an alert that we could be talking about bond. That wasn't on my radar, not for bad reason. I didn't think it through. And she doesn't have a W next to her name. That's the other way I get a sign. If you want to have people reach out to see,
Sure.
I just figure if we've got, assuming Ms. Wood is going to represent her, if she's not, then we wouldn't have that conversation today anyway.
Right.
Okay. And we can, they may be talking for a while, so we can handle Ms. Jones as soon as Ms. Wood's done talking with her.
That sounds good, Judge.
Unless the hours that be holding away from Colorado. I'm gonna say. And they're all yours. They don't only make. It's no, all this stuff to that. It's not all. So, rules need to take out some penalty, if something on the record. Nobody's getting. Yeah, so, those things that's going to happen. Already. We're taking a minute, as you get up, going on. I mean, take that, take from, you know. Which is really the stuff, so I'm going to say that way, it's the direction. Well, listen. Yes, right, I said it, sure, there's like. It's all about on my day, but you can tell that from that. I need to go check it there.
Is not qualified, Judge?
Okay.
Right. Even if you have, if he's right here, just like kills it in the pig. But Judge, I am happy to work with her today. There might be something we could work through possibly.
All right, so I need Deputy Gordon back in here. He's checking on something, but that would be great if you, just so we could have a conversation.
Yes.
Deputy Gordon, did you confirm everything? All right, Ms. Jones, I need you to come up here, please, to the podium. One second. Okay, so a couple things. One, Ms. Wood tells me that you fall into that category of, even though you don't feel particularly economically vibrant, your financial resources exceed the caps for appointed representation. So you're going to need to work on getting a lawyer. Two, it was brought to my attention that as a byproduct of being included in this indictment, a grand jury warrant was issued, which means you need to be booked in, which means you have to go into custody. What I would like to do with your approval is talk about bond, and Ms. Wood has agreed to, on a temporary interim basis, represent you for the discussion about bond. I want to assure you, you are entitled to a bond. I'm going to grant you a bond. We just need to understand what the contours of the bond would be. We had very long discussions about the bond for Mr. Jones, as well as the one for Ms. Brown. I don't think we need to talk quite as long here because it will be similar. Unless I learn something about you that makes you very, very differently situated, that you fled to Costa Rica many times in your past, and then that's a different situation. But assuming it's not that, then I don't know why the bond would be all that different from the other bonds that I set. But I did need to deliver that unwelcome news that you will briefly go into custody until you can post the bond. The bond is meant to be a reachable, reasonable bond, so it's not going to be $1 million because I might as well say no bond. So that's not how this will play out. But that means there are going to be two financial outlays in the near term, posting bond, and then in the pretty near term, getting yourself a lawyer so that we can move the case forward. So I just wanted to explain that. Do you have any questions about what we're going to talk about this morning?
No.
Okay. And are you comfortable having Ms. Wood be your advocate for the purposes of setting this bond?
Yes.
Okay. All right. Then if you want to sit at council table with Ms. Wood, I will let Mr. Wooten start and let me know what he thinks bond should look like, assuming he thinks you're entitled to a bond. And I will certainly hear from Ms. Wood. I may have questions for you directly, Ms. Jones. And there may be people who are victims in this case who want to be heard. They're entitled to be heard whenever we're at a juncture like this. And so there'll be a time when I hand the microphone over to them, if you will. So we'll hear from all those folks. Mr. Wooten, if you would get us started, please.
Sure, Judge. Kind of consistent with what the court's already stated, we would recommend essentially the same bond that is on Mr. Darren Jones's case, which is a total $10,000 cash only bond. We had some discussion, I think last time, about why the state's recommending a cash only bond as it relates to all the defendants in this case, but I believe there are 5 counts. So we would just recommend 2,000 cash only on each count for a total of 10,000. With just the special conditions being that the defendant appear at all future court appearances, commit no further crimes, not possess any drugs or medication without a valid prescription, not possess any weapons, have no contact with any victims in the case, which I can, if the court wants, I can read those out, but they're also in Mr. Jones's bond order.
I'm pulling up his bond right now just so I can follow along. So give me a second. Okay, so this was a consent bond that, for some reason, Judge Schwal signed it.
Not
What's
sure.
going on there? But it had my name on it, that got crossed out. Maybe I wasn't available, but Ms. Mormon, so Mr. Jones's lawyer and you jointly proposed this. The new indictment has fewer counts, or Ms. Jones is just named in fewer counts?
Ms. Jones is just named in fewer counts.
Okay. because there were more counts for Mr. Jones. It does list all the way through DD. So 26 plus 4, 30 victims. It's the same.
Yes.
Okay.
One difference would be that's paragraph 6 that lists no contact with co-defendants or co-conspirators. Like I stated before, Ms. Brown is Ms. Jones's daughter, so I'm not gonna ask the court to prohibit them from contacting one another. I think there might be some joint childcare responsibilities as well, so.
But it would be no contact with whoever Brandy Stone is, no contact with Mr. Jones and Jade, I think that's how you pronounce the first name, Nelson.
Yes.
Okay,
Yes.
all right.
And then again, the defendant refrained from holding herself out in any way as an agent, broker dealer, institutional investor, insurance company, investment advisor representative, issuer, or any other position or profession associated in any way with the offer, sale, purchase, or any other dealings in securities. That she also refrained from holding herself out as any person authorized to deal in insurance, that she not conduct any financial transactions on behalf of another person, not serving as an accountant, bookkeeper, fiduciary, or holder or manager of funds for any other person, organization, business group, or other entity, that she not leave the state of Georgia, and if she has a passport, that she surrender that within 24 hours.
Okay, those are the conditions in Mr. Jones's bond as well. Given what I understand about the allegations, those conditions made sense for his situation. So I don't know why they'd be different here. Ms. Wood, what are your thoughts about that bond amount and those conditions?
Given my very limited knowledge of this case, I would just ask the court to consider making that a good bond, surety bond instead of cash only. Ms. Jones has 3 children. One is 14 years old, so she'd be the primary caregiver for that child. She has a stable address in Dallas, Georgia. She is gainfully employed. She works at Tanner Medical Center as well as Ridgeview Institute. And so I would just.
What was the second one?
Ridgeview Institute.
Okay, all right.
And so, yes, I'm just asking for that to be a regular bond.
In terms of the money, not the conditions are not very regular because this is not a regular indictment, but you're saying 10,000 good bond.
Yes.
Okay. Ms. Jones, what do you do in those 2 jobs?
I'm a licensed professional, do I need to say?
No, I just need to be able to hear you.
I'm a licensed professional counselor. I do mental health assessments.
Okay. Same job at both those places?
Correct.
Okay. Are they both part-time or one is full-time and then you have a part-time on top of it?
Both are full-time.
Both are full-time. So you work 16 hours a day?
I work day and night. I work 12 hours, 3 nights a week, and I work 8 hours, 5 days a week.
Okay. And in your household in Dallas are who, like if you invited me over for lunch on a Saturday because you weren't working, who all would be there?
My 3 children and my 2 grandchildren.
Okay.
Possibly my mom.
Talk about a sandwich. Okay. So your 3 children, one of them is 14 and what are the other ages?
26 and 28.
Okay. And one of the 2 adults is Kayla Brown?
Correct.
Okay. So Mr. Wooten, that's the address you understand Ms. Brown to be at, would be Ms. Jones's address?
That's my understanding.
Okay. And is she the 26-year-old or the 28-year-old?
26-year-old.
Okay. The 28-year-old, does does he work outside the home?
He does.
What does he do?
He's a mental health tech.
What does that mean?
He works at Ridgeview Institute.
Oh, okay. Ridgeview is helping take care of the household. And where is that in relation to Dallas?
It's in Smyrna.
Okay. All right. And then either Kayla or your son has kids and those kids stay with you also?
Correct.
Okay. All right. Mr. Wooten, why don't you get on the record again, because I don't remember, why you were insisting on cash bond versus good bond?
Sure, Judge.
Just to make, I could shortcut it. That's in effect a bigger bond. It's a $10,000 amount, but it requires more of a financial outlay and thus investment and commitment from the person posting the bond than if it's a fraction of that posted through a bonding company.
Sure, Judge. So, pretty typical in our white collar unit cases, we recommend a cash bond. And to take a step back, when I'm dealing with a defense attorney, typically what I'll say is like, it can be $100,000 good bond or a $10,000 cash bond. I'll let you choose, and they almost always choose the cash bond just because of the opportunity to have that money returned if the case goes in their favor in the future. And then we also prefer it because if it results in a conviction, we can convert that into restitution. So
Got it.
that's the reason for that.
Okay.
That recommendation.
Understood.
I did forget to mention, I believe that there is a victim that's on that may want to be heard, Kathy Butler. And if she's not on, she's provided me with a statement.
She is. There's a Kathy Butler, and then iPhone just jumped on. I don't know if that's yet another person, but let's start with Ms. Butler. Good morning, Ms. Butler.
Morning, Judge. How are you?
Hi there. Can you hear me?
I can. Can you hear me?
Yes, ma'am. And then just before you go, there's a Ms. Palmer. That's the iPhone. Is that another victim?
She is, Judge.
Okay, so I'll certainly hear from her if she wants to be heard. Ms. Butler, I don't know if you, and I have a bad memory, so I apologize if you were present for virtually the bond hearings before, but we're going through a similar process. The state has added a defendant to the case, Ms. Jones, the mother of Ms. Brown. And what we're talking about right now is what Ms. Jones's bond should look like. I'm going to give her a bond. You're welcome to say, don't give her a bond. I'll hear anything you want to say about it, but I want you to know the outcome of the conversation will be Ms. Jones gets a bond. But I'm very interested in your thoughts about what that should look like and anything else you want to add.
Thank you so much. I just want to say that given the circumstances of the case and everything that has happened thus far, I would certainly be in favor of it being a cash bond. I just don't feel like in this whole situation, there's been any remorse shown. It has been a horrible impact on me and my family. And at this particular time, I feel like it should be the same for them. And also, I know that there's been a lot of speculation about, who lives where, who's taking care of who. But I would like also to go on record to say that just like in the other two defendants' bond hearing, I think there should be a no contact order for them as well, because there stands to be a chance for the case to be impacted by ongoing communication. I would hope that the court would take that into consideration because, as I said, it does not seem that there's been any remorse shown, and there seems to be more to this than what may meet the eye at this point. Thank you.
Got it. You're very welcome. I appreciate you sharing that perspective.
Thank you.
Ms. Palmer, did you want to be heard?
Absolutely.
All right.
Hello?
Yep, hold
Can you
on
hear
one
me?
second. I can. Give me 1 second. There we go. Okay. Yes, ma'am. Have you been able to hear what we were discussing?
Just a little bit, yes. As far as the bond is concerned, I feel like I don't want her to have a bond, but if she has to get one, I feel that it should be a cash bond. I remember her being there upon my initial payment that I made to Ms. Brown in the amount of $2,500. She was there. She was the driver along with Ms. Brown's daughter. This has been the most uncouth, heartless thing that anybody could do to people who they considered family and friends. She has no conscience. I am forced into working a second job just to recoup what I've lost, thinking that this was a investment that was legit. I have suffered greatly. My family has suffered greatly. My home has suffered greatly, and they were all in cahoots. She is online flaunting, a luxurious lifestyle at the account of me and my family and others. She's living this life by scamming us. I feel like all three of them should be locked up for a substantial amount of time. I would still like to prosecute them to the fullest extent of the law. I do not feel any remorse for them as far as them being free while I'm still continuing to suffer emotionally, mentally, and financially. This has just been the worst experience that I have ever gone through, and I am still distraught over it. And I feel like they should pay all of them.
Okay, Ms. Palmer, I appreciate you sharing that perspective. I'm glad that the district attorney's office is keeping you and the other victims in the loop so that you have an opportunity, one, to see and hear what's going on, and then to participate when it's appropriate. And this is one of those junctures where it's important for me to hear from people who were impacted by the allegations in this case. And it's bringing back my memories of what I heard. It may have been from you, but there were people who were also very vocal and firm when we had the bond hearings for Ms. Brown and Mr. Jones. And it is clear that that hasn't changed. So I appreciate you sharing that input.
Thank you for allowing me to speak, Judge.
You're welcome. Appreciate it. Okay, Ms. Wood, anything more you want to add on behalf of Ms. Jones?
Judge, I am preparing if the court would consider a round trip order for whatever the bond ends up being, which is where she could take that with her, or I file it. I don't know how it gets to the sheriff's office, but I think they still accept those. After?
I don't know. I'm all for it. I don't have an issue with that. In fact, I was going to ask, I don't know how Ms. Jones got down here and if people are with her and if they have a way to get back. I know there are people with her, but if they have a way to get back, the important part is getting the bond in place. That does require getting booked in, but there are a couple ways to make that work. There is an active warrant, so I can't let Ms. Jones leave through the door she might want to leave through. But I would hope that we could expedite the process.
Thank you, Judge.
So if you do have an order, I'm happy to take a look at it. And I don't think you have any opposition, Mr. Wooten, I mean, the point is to get the bond in place with the conditions in place.
Sure, Judge. And I'm actually looking now, I think I've got a Microsoft Word version of Mr. Jones's bond. So that may save us a little bit of time.
Yes, well, that was going to be my request. I'm looking at it in Odyssey, and I can always try to turn that PDF into a Word file. But whether you find Ms. Brown's or Mr. Jones's, if you could email to Ms. Nelson, that you don't need to send it to Ms. Wood. I mean, she's not going to be plugged into it after that. But that just is the template, and then I'll tweak it so that it reflects Ms. Jones and not Mr. Jones. Okay.
I've actually got it here, Judge. I'm going to send it.
You can just send it to me.
Forwarding.
Yeah.
From Mr. Jones.
Okay, great. All right. So Ms. Jones, here's what's going to happen. I am going to set a $10,000 cash bond. It'll be $2,000 per count. And then it will be all those conditions you heard about, none of which impact your ability to be a mental health professional at those two facilities, unless you are also a broker dealer at those facilities. It doesn't sound like that's the important work you do at those places. But while you are out on bond, you and Mr. Jones need to not have contact. That contact would be through lawyers. I will let your living arrangement persist. So Ms. Brown will stay there, and obviously you're going to be interacting with her. She's your daughter, and your grandkids and her kids are all in the same space. So that can persist as long as I don't hear something from the state about there being issues arising from that. I will work with Ms. Wood to have the processing happen as quickly as it can. And then when you do post that bond and get out, you'll need to figure out how you're going to engage a lawyer. And what I'm going to do is reset this for 30 days. And you'll need to be back here in 30 days, unless by then you got a lawyer who did what Ms. Brown's lawyer and Mr. Jones's lawyer did. They're two different lawyers, where they filed what we call a waiver of arraignment, saying, look, we're pleading not guilty. You don't need to read us the indictment. We know what the charges are. And then we'll just start that process of getting all the discovery, all the state's evidence to your lawyer, and you and your lawyer will work on that going forward. Do you have any questions about what I just described? Ms. Wood, anything else?
No, Judge, thank you.
Mr. Wooten?
No, Judge.
All right, then that's how we will handle this. And I will see folks soon after that.
Judge, you should have that in your.
It just hit,
Okay.
yep. Deputy Cole, how many is it 3 returns? Right, but I want to make sure I sign everything. 3 returns from block. Okay, all right, I'll sign those in a sec. You scared off Mr. Furlong. Is he talking with his client?
Yes.
Okay, all right. All right, Deputy Cole, do you swear or affirm that the contents of your 3 returns are true and correct to the best of your belief and knowledge? Did you get anything good? Yes, you're pleased with the results? Okay. Thank you, Ms. Wood, for temporarily representing
Of course.
Ms.
Judge.
Jones.
Okay, so we'll hang out and talk to the
You can come on up. Here you go. All right, are there more out there?
I'm still waiting on some.
Okay, all right, bring them by whenever. See it. So Ms. Davis and Ms. Wood, have you all met and exchanged contact information?
Yes, and we're gonna talk about some cases for this week after we're done here.
Excellent. And Ms. Rios as well, she just didn't have anything this morning, so why be here?
Correct.
Okay, got it. Tomorrow, we have our all-important pretrial meeting at 4. Has Ms. Dilligard told you what those are?
No, Judge.
Okay. That's when you and any ADA who has a case on the trial calendar convene with Ms. Rios and Ms. Wood, and we talk about, well, how is this playing out? And I'll hear, well, this one's going to be a plea. This is likely a trial. There's no way we can be ready on this one. So it makes the call of the trial calendar, which is on Thursday, it's a little less dramatic for us, but it's actually helpful because then I'm figuring out what are we going to move forward with. It also helps because we've got the added dynamic of Judge Emerson's consolidated trial calendar, and you have a case on that calendar. So you get to think about, well, I can't be in 2 places at once, but if my case isn't reached in front of McBurney, maybe my case in front of Emerson gets reached. Hopefully that wasn't news to you that you have a case on the consolidated trial calendar. Mr. Rao needs to let you know that.
Yes, Judge, that was news to me.
Okay.
Who is Mr. Rao?
No, he's
Oh,
talking about
Mr.
Gotham.
Okay.
And so, Your Honor, I will be taking Mr. Rao's place.
All right, then you get with this guy.
Yes.
So Mr. Rao is who I send the consolidated calendar to. I think he's going to keep that role. He didn't tell me that's changing. I do know that you're now sort of the line supervisor for Ms. Davis. But Mr. Rao is the person, Ms. McCauley used to do this, but it's sort of the person who is the clearinghouse for all the reports from the ADAs of like, oh, this needs to be second week. We're not ready. We need a continuance. And so he may have been bugging Ms. Dilligard about the case, but I think it's going to be Ms. Davis's case.
Yes, Your Honor, and I'm looking at it now. We have it.
Good. Excellent. What do you need from me? I don't think you need, there's a warrant, so you don't need paperwork from us. Okay.
Then you know that the victim from the car that followed him outside and he was a fight with a criminal called.
There were people in court
The victim family were,
for Carter Jackson. Really? Didn't see that coming. Huh? Everything seemed pretty calm on that one. It's a vehicular homicide.
Okay.
I don't know if it was a passenger in his car or if he hit some, I didn't even look at it. Okay.
That would be a goal.
Oh, it is? Okay. Okay.
Ms. Davis, did you leave Mr. Furlong with an offer? Is that what he's talking to his client about, or?
We are in talks with the offers. My understanding is that Mr. Furlong will withdraw the constitutional speedy motion and that we would ask for the notice to whichever calendar, whether that be
Whatever's
a
next.
plea calendar or a trial calendar, wherever it is in the process, but we hope at that time to enter a negotiated plea.
Okay. So you don't feel impossibly far apart?
No, Your Honor, there's just some steps that need to be accomplished before we would enter a plea.
Okay.
And I'm gonna go outside and grab, because I think that's the last item for today.
Yes, it is. Hey, Mr. Furlong, I was asking Ms. Davis for an update and she wisely said, well, why don't we talk about that with both sides in the courtroom? It sounds like progress has been made. This pretrial was very productive. Tell me what you think. Are we doing something today? Are we just gonna give people a little more time?
We need some more time, Judge. The reason he's been seen by a psychologist, we finally just got reports last Friday.
Mm-hmm.
So I just sent him to the Dilligard, gave mistakes, so we're talking about that. We've agreed with the court's permission, we'd like to reset it to a different final plea date. She wants to get some more information, probably subpoena the records. And we're gonna withdraw our constitutional motion.
Okay. So a couple things we can certainly do that. Let me tell you where we are right now. This case is on the July trial calendar. Mr. Chastner's final plea rights were preserved. We didn't do the final plea. It was on an end of May final plea calendar, but you had this pending motion that I hadn't gotten to yet. And so we just rolled you off that straight to the trial calendar, but preserved Mr. Chastner's final plea rights. So my thought would be we just keep the case where it is. So July 10th is when the calendar would be called. That's not when the trial would be. And it doesn't sound like this is going to be a trial. But that gives everyone a month and a day to work through things. And if before then you all reach a negotiated resolution, we don't need to wait till that day. That day is zany. There are 30 cases. Everyone wants to do something. So if before then you all have reached either we agree or it's negotiated, but there's a range, the state's going to recommend X, you recommend Y. You just need to reach out to Ms. Nelson, my litigation manager, and we'll figure out, since Mr. Chastner's on bond, we just needed to work with your schedule and Ms. Davis's, and we'll get you into court. So we don't need to wait till the 10th, but that'll be our backstop because it's on a trial calendar. And again, it doesn't sound like it'll be a trial, but we could do the plea on that day. And Mr. Chastner has preserved his ability to withdraw the plea. If I get a wild hair and say, your recommendation's crazy, 10 years in prison, you can say, whoa, that's not anything I was interested in, nor is that something I'm going to do. But I just want you to know he still has his final plea rights. Does that work?
That would work. The only thing I'm gonna have to subpoena some records is from a company out of state, so I don't know if I'll have them by the 10th.
Okay. Well, if you're subpoenaing them for trial, that trial date's been out there and you'll need to move as fast as you can. If you're subpoenaing them because it's going to help the case work out, it may be that you and Ms. Davis say, Judge, could we have more time?
That's what we talked about.
Yeah.
That's probably what we're gonna need.
Okay, the indictment's not all that old. The underlying conduct is pretty old. We're on year 2+, so I'm anxious to move it forward. But paperwork can move slowly. And if the state is telling you, we're not comfortable getting closer to your recommendation without seeing certain information that you can get only by way of this out-of-state subpoena, you can enlist my support to try to pry it out of the place. But let's at least aim as our stretch goal to have this resolvable for that July 10th date. Okay?
Because that gives me a firm date to put on a subpoena, assuming, and that's what,
July 10th is a very firm date.
yes.
Okay. Ms. Davis, anything you want to add on that front? I know you're just processing this one, but does that seem doable-ish?
Yes, Judge, nothing further.
Okay, all right. Then we will see you all on that day, if not before. If magically you get the documents before and they're persuasive with the state, then let's reduce the congestion on July 10th and get everyone in before. Okay?
Okay. Judge, just a matter of housekeeping, if I remember, I had filed a leave of absence several months ago. And I think I have a leave from the 1st to the 10th of July.
Let's look. You did file a leave of absence on February 28th, and you do have leave. You have a lot of leave. You have leave 1st through 10th, 23rd through 29th. So you don't need to be here on July 10th. That does not remove the case from the trial calendar. So it may well be that you want to work with Ms. Davis to resolve the case, and I'm making it up, but on the 11th, when you're back would be when we would take the plea. We just wouldn't do it on the 10th unless you decide, you know what, I don't need that much vacation. I'll come back on the 9th so we can handle this on the 10th. You do have leave for that day. It's protected. But that we're not removing the case from the trial calendar because trial doesn't actually start until I learned I get a bonus week of trial because the DAs aren't going to the prosecuting attorneys conference down in Jekyll. So it turned into a 2-week trial calendar. We'll have plenty of time to do Mr. Chastner's case if it's not resolved. All right?
Sounds good.
All right. Anything else?
No.
Thanks. So I do need you, Mr. Furlong, to file a withdrawal. It can be one sentence. Defendant hereby withdraws his constitutional speedy trial. That'll clean up the docket.
Will do, Judge.
Okay.
Thank
Great.
you.
That's it. Thanks. The Colonel was just here. I was going to say, I want to say, hey. Okay.
So most of you I'm trying to work on a proper date.
Yes,
So do you want to kind of run that by? I need to do it before Thursday. So.
I want you to look at that Rio's case first.
I think we're done with this morning's Zoom. Thank you, Ms. Rivers and Ms. Simpson.
Okay, Judge.
See you guys tomorrow.
Yes, Judge, I'll be in person tomorrow.
Yay. All right.
Thank you.
Bye.
Thank you, Judge. Take care.
Yeah, thanks for that great case. Looking forward to it. Thank you for getting me that bond information because I can get that entered and